Hi, everyone. I'm just David Glazer here to pop in quickly to do a couple of announcements before we get started talking about HIPAA and data breaches. So first off, remember, if you have sound issues, if I sound like I'm underwater or anything like that, you can dial in. Chad's putting the dial-in number right now in the chat box. You can use the chat box to ask questions. If you have any difficulty seeing the chat box, sometimes it'll disappear and you just need to move your mouse up into the middle of the screen, kind of hover up there, and you can get that bar to reappear and then click on the chat box. Much like the puzzler in Car Talk, the webinar is going to take a vacation in September. In October, we're still working on the topic. There are a few possibilities. We may be doing grab bag, but we'll let you know about that. Breyer has a really great idea that she came up with. We may try to do an all-day marathon of old webinars. So if there is a webinar that you would love to hear again, you can let us know. Of course, you can listen to them right now on SlideShare. All of our past webinars are there. But if we do them live, and we'll do them live with Q&A, you could get CLE credit for it. Also, if there are other topics you're itching to hear about, we like to hear topics, please shoot them in. Now, I used to do confidentiality advice myself. I loved it. It was one of my favorite areas to do. But it's gotten too hard. And now that it's hard, I rely on people smarter than me to do this stuff. And we've got 3 of them gathered here. But speaking of people smarter than me, I got an email last week from someone who said, wow, I heard Katie do something. And I really wish I could have hired her to do something. And I called this person up and said, well, why can't you? And they gave me all these various reasons why they thought they couldn't call and hire Katie. And they were all crazy. And so I just want to say to people who think that you can't call and hire Ann or Katie or Breyer, you can. So, without further ado, I now turn it over to one of the people smarter than me, Katie Ilton.
Thanks, David. So today we have Breyer Andreessen and I, who are from our health law group and who you've probably heard many times. And we have a fabulous guest appearance on our webinar series, and hopefully she'll be appearing more often than just today. Ann Ladd. Ann is an attorney who does technology transactions in the life sciences area. She also does a lot of advice on data security, data breach response, and when something like this, when a data breach occurs for one of our clients, we are often calling Ann because she has a lot of expertise in this area. So thank you, Ann, for being with us today.
Thanks for inviting me.
So just a few comments about where we're going today. We know that not all of you on the phone are necessarily HIPAA covered entities, but many of you are, and we wanted to cover some lessons learned and some lessons that we're seeing our clients learn with regard to recent data breaches. And these lessons are not just lessons for HIPAA covered entities. They're lessons for all sorts of companies that have confidential data and individual personal data. And so we think there's a lot to learn on sort of both sides of that. We will be covering the HIPAA requirements that come up with regard to data breaches, but we'll also be talking about best practices that both covered entities and non-covered entities can certainly use to make their organizations safer. We're also not, we could have an entire day on data breaches. What we wanted to do is focus in on some topics that have really been plaguing organizations lately, and at least give you some ideas for focusing your efforts if you're overwhelmed by this topic. So let's just start out. We're going to talk a little bit about some recent healthcare breaches. Before we get into a couple of examples, I just wanted to give you some data points here. As of February 2015, OCR had said that they had received over 1,000 breach reports where 500 or more people were affected, and over 150,000 breaches involving fewer than 500 individuals. And we'll talk a little bit later about if you're a covered entity, you are required to report any breach to OCR, even if it involves less than 500 individuals. So there's just kind of some data points to start out with. In 2010, the HITECH Act required HHS to provide a public database or reporting of all of those breaches that affected 500 or more individuals. And that's been dubbed the Wall of Shame. And just pulling some stats from there, I believe this is recent as of this spring. This data actually came from the Office for Civil Rights. So just looking at sort of where the PHI is resting that has been breached, you can actually see that PHI and paper records is still high on the list of breaches and where the data is coming from. And then certainly laptops, desktops, servers, portable electronic devices, flash drives, your iPhone, things like that. So we do see data in a variety of places being breached. Maybe more informative is this slide, which is talking about the types of breaches, how breaches occur, at least those that are covered entity breaches affecting 500 or more individuals. As of this spring, according to the Office for Civil Rights, theft of PHI was still one of the highest category or bucket. And then you see a little bit further down in the smaller categories, you see hacking IT incidents being still significant, 7%. In fact, Anne's going to talk a little bit about recent trends are showing that hacking and IT issues, firewall issues, malware are that's a growing trend, and so that's not going to go away. We might see these numbers change. So speaking of hacking, let's talk a little bit about the Anthem breach. This is potentially the largest healthcare breach that we've seen. We are still getting data and reports from the media. We don't have the Office for Civil Rights necessarily telling us information about this breach yet, so we're still piecing together what happened. But this was first reported to the media in February of this year, and potentially more than 80 million Anthem members in multiple states' information has been affected. Again, we haven't seen that number coming directly from Anthem, but that's what sources are saying. Pretty significantly sensitive information breached: name, birthday, address, email address, and then maybe most notably medical ID, social security number. So I'm sure many of you know that the Medicare ID for beneficiaries is usually the social security number of the beneficiary plus some letter. That's not exactly great because that means that information is stored in various healthcare, social security numbers are stored in various healthcare entities' databases. I was trying to figure out if Medicare is going to change that, and apparently Medicare is issuing new ID cards that do not have the social security number or Medicare ID on the card. But at least as of this spring, they said, gosh, it's such an administrative nightmare to totally reassign numbers that they haven't yet done that. So social security numbers are out there even if you aren't calling them a social security number, they're in your Medicare ID. So that happened, that data was hacked at Anthem. No credit card information at this point that we know of, or medical information. But I think just the information that was hacked damage has been done. So what happened? So far we know that there was an attack on an Anthem database. There is speculation that this was a state-sponsored hacker. One report said that one theory is that malicious software was used to get an employee login and that the password the hacker already had. And so with that combination, they were able, and the use of the software, they were able to get into a database. This was discovered when one management individual at Anthem noticed that someone was going in and requesting information under his or her ID. And so this is, important lesson is that your employees are your eyes and ears. And so it's really important to train employees on what to look for and to train them to report anything that might be suspicious. So that was how it was discovered. Apparently, one source says that social security numbers or the Medicare medical IDs were not encrypted, so they couldn't avail themselves of that protection under HIPAA, where if you have hacking of encrypted information, it's not necessarily a breach. And I guess information was tracked to some outside website where it was being transferred to, and then it was locked down there. Don't know yet if that information went to other databases. So of course it's just been a nightmare for Anthem. They had said originally that they were going to notify folks who are affected by email or by a letter, and then what followed, I think just a few days after the initial breach report, is that they had reports from members receiving emails that said that were supposedly from Anthem but were not, and those emails were saying, "Hi, this is Anthem. Your information has been breached. You can use credit monitoring if you enter all of your financial information and give us that in order to enroll you." And that was just another way to get more financial information from the people who potentially had been hacked already. So that was a bit of a nightmare. And so revised their plan and decided that they were just going to send notices through the U.S. mail. So something to think about when you're planning your your notification method is to think about how that notification method might be vulnerable. So Anthem's offering a lot. They're offering free credit monitoring, ID protection for up to 2 years. We'll talk a little bit about costs of breach. Someone is saying, one source said that they estimate this will cost $200 per individual affected. So multiply that by 80 million and you have a gajillion dollars. And I know there's been at least one class action lawsuit filed. So one thing that actually Breyer brought up when we were talking about Anthem is, and one lesson learned is, the Anthem breach happened in February 2015. And OCR that's the agency that enforces HIPAA, will most certainly investigate them. But they probably won't get around to doing it because they're slow for a couple years. And so if you're Anthem's counsel and you're on their data breach response team, you absolutely want to be making sure that you document everything that you're doing so that when OCR comes along and asks, or any other federal agency that's investigating you, ask what you've done, you don't have to recreate that later. So that's certainly one lesson learned. Make sure you're writing down what you do. So another example where we actually have OCR resolution recently is the St. Elizabeth's Medical Center example. So this is a breach that occurred in November 2012, and we're just now seeing in July, just a month ago, the settlement. So there's a lag time between breaches and when OCR gets around to figuring out what they're going to do. This was another technology-based breach, and this was a little different in that it was reported to OCR actually by an internal person, by an employee. So another reason to have your employees trained to report internally, not to OCR if something is going on. What was happening is that employees were storing PHI of patients on a cloud-based application in the intranet, and they had done no risk assessment of the vendor, and there was no business associate agreement. There was also another separate incident involving a stolen flash drive, and so this was reported to OCR, and they came up with this settlement amount. And in addition to that settlement amount, they entered into a corrective action plan, which is often what you see when OCR resolves a case with a covered entity and they don't issue civil money penalties. What they'll do is they'll come to a resolution amount, or basically a settlement amount. That was the $218,000, and then they'll probably have you enter into some sort of corrective action plan. So this is just an example of what one might look like. St. Elizabeth's has to basically do a lot of self-assessment and reporting on their security vulnerabilities. They have to do unannounced site visits to assess whether their policies and procedures are working. They have to do some interviews, and they have to, as they do all of this, they have to report it to OCR, and OCR has to sign off and say, okay, you're doing it the right way. So it's quite cumbersome. It takes a lot of resources, and there's a lot of back and forth with OCR over the next 12 months.
I think the situation with St. Elizabeth's is a good illustration of why many people in the industry are predicting even more breaches in the healthcare industry. The fact that Medicare numbers are Social Security numbers, the Social Security numbers are what has the real value for people who have, a bad purpose in trying to get hold of that information. And you've got, unfortunately, a circumstance where lots of clinics, hospitals don't have the resources to adequately do the kinds of things you need to do to lock all the systems down. People want access, and we've got a drive for more mobility, and so employees may seek out cloud resources without checking with IT, et cetera. So you end up with kind of a perfect storm of information and access not being secured. Absolutely. And in fact, one organization, Sky High Networks, reported on employee use of cloud services, saying that at an average healthcare organization, employers are using hundreds of cloud services, and probably the IT department doesn't necessarily know about it. So if you're the in-house counselor, if you're the in-house privacy officer, I think one of the takeaways from this is figure out what cloud services your employers are using in all areas of the organization, get a business associate agreement in place, and do some vendor diligence that Ann and Breyer are going to talk about.
a little
It
bit.
reinforces, I think, something else Briar would talk about in the risk assessment area of starting with an understanding of what you have and where it is.
Right. So then just one more example of a recent HIPAA settlement is the Anchorage Community Mental Health Services. This was announced in December 2014. It was at least a year or two back that the breach actually happened. This was a malware incident. It was your classic organization not updating their software, not using available patches that resulted in vulnerabilities in their firewall. In addition to that, when OCR investigated, they found that they had not done a risk assessment that was required to do under the security rule, or they had done one and it had been quite a long time since it had been updated. Also, they had security policies, but they appeared to be template policies that had not been customized or followed. And so it's important to actually document the policies that you're doing and make sure you're updating them as they change.
I'm going to talk a bit about a few incidents that have occurred outside the healthcare area, just to illustrate some of the other fact patterns that we're seeing, because they can apply as equally in the healthcare setting, and because they also teach us some things about best practices. It seems like every day there's some headline about a data breach, many of which have affected retailers like Target, Home Depot, Michaels, Neiman Marcus, etc. In the Target situation, we're starting to learn more and more about how that breach may have occurred. And it's likely that the hackers in that case found information about Target's own internal system design and vendor relationships from some public postings, which described how Target was handling vendor relationships. The hackers then targeted a vendor, and in this particular case, a heating and air conditioning vendor, and did a phishing scam. So sent out fake emails to employees at that vendor, hoping one of them would bite and actually click on a link, which an employee did. And through that link, infected the vendor's systems with some malware. Now, that malware was a known vulnerability in a system that could have been patched, but the vendor hadn't done it. So we have a breach in patching and an employee who's fallen for a fake email and clicked on a link. The consequence of that is the malware is installed on the vendor system and now is sitting there just watching traffic until an employee at the vendor actually logs in through its credentials to the target systems to do updates or maintenance or whatever they're doing on the air conditioning and heating system, and through that link, then the hackers got into the target systems. What happened after that, still not public. There were some other errors, obviously, within Target's own firewalls, but that's how they got in. It's really the same kind of fact scenario that happened with Home Depot. There was a vendor. I'm not sure what the vendor did in this case, but there was a vendor. An employee's IDs were compromised. The hacker installed malware, exploiting a patch in the Microsoft system that was known and the vendor hadn't installed yet. And once again, that malware was used then to watch for logins to the Home Depot system. So in both these cases, you can see a common fact pattern. Vendors ended up being the road into the company's systems, and it was through employee behavior and failure to patch and manage to avoid malware. So we'll talk later about some lessons learned out of both of those.
Right. So I won't belabor the parade of horribles here, but certainly data breaches are expensive. A lot of costs can come out of them. I think most notably, the costs are not just having to notify the individuals who are affected. That is certainly a giant cost, but there are other things that can happen. And so as a result, when you're negotiating a vendor agreement or a business associate agreement, you want to ask for indemnification for those costs, and you want to make sure that the indemnification is not limited just to notification costs, because there are lots of other things that can come up and expenses that can trail on for years after the actual breach. So certainly think about that when you're negotiating your indemnification clauses. One consultant or one organization out there says $230 a head for costs, the average costs. I've seen estimates anywhere from nothing less than 100, but 150 to 300 something. So keep those amounts in mind also when you're thinking about cyber liability insurance, which we will get to soon.
So, and this is Breyer now. With all of this, as Katie said, a parade of horribles, there is a ton to worry about, and it's very easy to get overwhelmed. And so we'll talk a little bit about what are the things you should really focus on as you're going through and thinking about what to do for your organization. And the big one, the first one listed here, is the security risk assessment. And really most of your compliance efforts for electronic security for sure will flow from that assessment that you do. A good one is also going to cover other areas that are not necessarily electronic but will also be helpful. Just simple things like having locks on doors, or appropriate signage and appropriate training for people. Even as Katie mentioned, the internal reporting when there is an issue that comes up so that it can be fixed on the front end. So security risk assessment, managing vendors, which we'll talk about, having a data breach response team and plan because something will happen eventually, and then employee training. So the risk assessment, again, it's part of any good security program for anybody. It's required under HIPAA and also required under the meaningful use standards. And it is, according to OCR, the biggest failure that covered entities have out there. One failure is a failure to do it at all, and that is a big problem, and we saw a couple of those examples. Another is a failure to have a complete assessment in place. So you might have done part of your security risk analysis, but maybe it covers only your electronic health record, or maybe it addresses only laptops or other things. You need to have the complete assessment that addresses everything, all of the places where you've got information. And then failing to follow through on the assessment that you've done is a problem. You want to make sure if you identify something in your security risk assessment that you go ahead and fix it. And again, there are compliance reasons why that's a problem, but just practically speaking, it's a good idea to do this thorough analysis, even if HIPAA and meaningful use are not part of your compliance obligations, because if you've got information and if you've got people-sensitive information and you fail to protect it, that's going to be a problem, and somebody will have an issue with that. So how do you actually do the security assessment? What should it look like? This is an ongoing issue. OCR did publish some guidance back in 2010 that addresses some of the basics of it, and we'll get to that. What is required under the security rule, the HIPAA security rule for a risk assessment, you have to conduct an accurate and thorough assessment of potential risks and vulnerabilities to your PHI. That's as much as they say about that. And then they talk about the risk management, so you're implementing measures to reduce your risks and vulnerabilities. You've got a sanction policy in place to punish people who aren't doing it right. And then you do an information system activity review with audit logs, security incident reports, basically so that you are showing that you're keeping track of what's going on and keeping track of where the problems are. We'll talk more about how you do it and where you can look. But make sure you are assigning responsibility to somebody, to a security official. It could be a combination privacy officer and security officer. It might be your head of IT. It might be just the security officer, but make sure that there is somebody who is quarterbacking this whole process, because there is a lot to keep track of, and you don't want to assume that somebody is handling it when really everybody thinks somebody else is doing it and nobody actually is. I have the term flexible here in all caps because the security rule does not dictate a specific way that you have to do the security assessment. You are supposed to look at the size of your organization, what kind of technical infrastructure you have, and your hardware and software capabilities, the costs that go along with putting things in place, and also the probability and criticality of your potential risks. So they want you to be flexible. They intend this to be scalable. So if you've got a smaller organization with just a couple people, it doesn't mean you don't have to do the assessment, and it doesn't mean you have to do what's required by the security rule, but it does mean that the actions you take are going to be different from a larger system. And obviously, if you're a larger system, you need to pay attention to that and pay attention to more of the kind of industry standard best practices for your size of an organization. So as far as who should do the risk assessment, again, that's going to depend on the size of your organization and the skills that you have internally. You can have a purely internal team. You could have purely an outside vendor. In some cases, it's going to be best to probably have some sort of combination. And if you do hire an outside vendor, you are still going to have, in almost every case, an internal person who is going to be, the head of the team, who's going to be in charge of follow-up and assessments and making sure that your outside vendor is doing it right and that the stuff that they are finding is actual stuff, and that they're not recommending crazy things, and that you're able to do what they suggest doing. As far as what the risk assessment should cover, for HIPAA purposes, it needs to be all of your PHI. So electronic stuff, but also paper files and your devices, your mobile devices, your desktops, your copy machines, anywhere that PHI resides, you need to keep track of that. And keep track of when it's coming from external sources. So if somebody is emailing you information all the time, then you need to make sure that that email is protected once you have it. It would be helpful as you're doing this to go through the actual security rule requirements, because that will help you sort of address the type of things you need to have. These bullets here are the things that the OCR has said in their 2010 guidance. This is what your risk analysis must include. And I won't go through all of those, but those do need to be in there. And I think our Chad has just put up in the notes section of your computer screen a website where there is a very helpful, downloadable, free security risk assessment tool. There's an electronic version of that, and there are also paper versions available on that site. It's the healthit.gov site, and that does provide a pretty good framework for going through things. It's not a quick process, and you're going to have to probably have more than one person involved in answering the questions, but it is a useful thing, and it's a useful place to get started if you have not done your risk assessment yet. The other piece of the risk analysis is keep going, keep doing it. So it is not a thing that you can do one time and then not do again and have it checked off your compliance list. It's something that has to get updated from time to time. There is not a specific requirement for when you have to update it, but you do need to keep it going. OCR has said in at least one investigation that I've worked on that when the IT environment changes in any way, or your physical environment, you need to reassess your whole security platform and do the full risk analysis again. I don't know that I completely believe that, but if you are making a change to your software, look at what that software change is going to do to that particular piece that it affects, and continue to reassess as you go. Set yourselves a minimum amount of time where you're going to do a reassessment and put it on your calendar so that you're doing it. And again, if you find something wrong in the analysis, then either fix it or come up with an alternative. Give yourself reasonable deadlines and then meet those. OCR does not like to see a security risk analysis that says, we found a medium to high risk vulnerability here, and then not have a timeline for changing it. They like to see a plan, and they like to see you meet that deadline. So don't give yourself a deadline that you are not going to be able to meet. And then we move on to the managing vendors, which is another huge part of this.
I was just going to say, Briar, on risk assessments, I don't think I've ever seen an OCR investigation letter that didn't ask for a copy of the risk assessment. Is that fair?
That is a very good point. They always ask for a copy of the risk assessment, and any time that I have seen where they have found fault with a covered entity, they also have thrown that in as you have also failed to maintain the security of information and failed to do an appropriate risk assessment because you had a problem. I think it's kind of a throwaway for them in many cases, but it's something that you want to avoid if you can.
Okay, so vendors, they're not totally separate and apart from risk assessments. You want to be assessing your vendors as part of your overall organization risk assessment. Vendors is an area where we're just seeing more issues come up in data breaches. So you definitely want to have a contract with your vendor, setting out your expectations. And in fact, HIPAA says you have to have a business associate agreement, as I'm sure you all know. The business associate agreement has to be written. It can't just be an understanding, even though probably most of you could recite in your sleep what they must say. It has to be written down. And we've heard OCR say that you should have your business associate agreement right away if a data breach happens, because I guess they think that it's going to dictate how the parties will act. If you have a really great negotiated business associate agreement that says what everyone's supposed to do, practically speaking, that would be great. But the point is, have it handy, because when something happens and involves a vendor or business associate, you're going to have to pull that out, at least, at the very least, for the OCR investigation. So Ann and I are going to go through, what your contract should look like. And I'll talk about what the required business associate element is, and then I think you will find that for most cases, we want to ask for more, if possible, from our vendors. So obviously the business associate agreement has to say that they can't use PHI other than what's permitted under the agreement and law.
And similarly, whether or not the vendor is actually going to have a business associate agreement, anytime you've got a vendor who's going to have access to manage, host, modify, see any kind of personally identifiable information or even company confidential information, we recommend making it absolutely clear that there's no use of any of that kind of information other than as necessary to perform the vendor services.
And I think that's what a lot of healthcare organizations kind of lose track of, is they are only caring about the PHI because that's the obvious regulated information, but vendors get a lot of other types too.
They do, and don't forget that while HIPAA covers PHI, many of the states, most of the states, also have laws that deal with the need to notify if there's disclosure of other kinds of personally identifiable information, so PII, and an incident can actually end up involving both kinds of data. So
multiple reporting.
And when it comes to other kinds of confidential information, the consequences may not be notification of a breach, but they could have other serious consequences, whether that causes you to violate an agreement with someone else or just lose something, have something become public that you'd prefer not to have been public.
So HIPAA says that the business associate has to use safeguards and comply with the security rule, including do that risk assessment that Briar talked about. And what else do we want them to do?
Yeah, so I think, a nice thing about the security rule is it doesn't mandate any particular technical security solutions, just a level of assessment and accomplishing controls. Similarly, I think it's going to be a rare case where you actually say you have to have this kind of firewall and this kind of authentication, although sometimes you might. Mm-hmm. But in addition to asking for compliance with the security rule, or in situations where HIPAA doesn't apply, again, when you're outside the business associate context, I think it's always wise to ask that the vendor continue to meet whatever the current industry standards are around security, because they do change all the time. You may want to have some contractually defined security measures that are particular, and you may want to consider whether to ask that the vendor be certified or audited by an outside group, and we'll talk about that again later. But just like the business associate agreement is, people on this line could recite what it requires. That's kind of handy because they're covered. Mm-hmm. A lot of times what we do in situations where there isn't going to be a business associate agreement is have a comparable kind of set standard contract provisions that go into some of those security requirements in a general level, and we'd recommend doing that.
And if you would like such an agreement, Anne is the perfect person to ask.
Absolutely, absolutely, and glad to share some example core contract clauses.
So, we want the business associate has to notify the covered entity if there have been unauthorized uses and disclosures, and many of you have negotiated the timelines. There are no set timelines in the rule, but there are certainly reasons to want to know that information as quickly as possible.
Right. And again, because in addition to needing to comply with HIPAA, you may be in a situation where you're trying to comply with other state laws or other obligations to your own other third-party contractors, we do recommend having those set time limits and having them be as short as you think someone could actually comply with, right? Sometimes we'll see people that try and put in immediate. Well, okay, it's probably not going to be
Possible.
immediate, spontaneous, but as little time as possible, because you will need time to analyze whether you need to report, whether you need to report to an attorney general, that sort of thing. So
So we want to know right away.
we want to know right away. Yep.
So the business associate agreement also has to say that any, I call them mini business associates or subcontractors, agents of the business associate, have to agree to basically the same restrictions for HIPAA purposes as the business associate.
And I would take it one step further, and at least for many kinds of responsibilities, say it's somebody who's hosting data, I'd want to know if they were using a subcontractor and have the right to consent to that or not. If somebody's just going to turn around and outsource that service somewhere else, you're going to want to be able to do diligence and know there's been a business associate agent agreement in place. So I'd want to know about subcontracting.
Certainly, there are a few different patient rights that patients have under HIPAA, and so if you're a business associate, you have to make information available for the patient if they request it. You have to incorporate amendments. You have to provide data that would allow the covered entity to make an accounting. So those sorts of things are specific to HIPAA.
Yeah, there's really not so much of a corollary
Sure.
there. Overall, you want to make sure that if the vendor's hosting, especially, that they're doing whatever they need to do to keep things current.
And for HIPAA purposes, the business associate at the very least has to make their practices and their policies and processes available to audit if HHS wants to see them. But certainly there are reasons why it's not just HHS
Right.
that we want to be able to see them.
Yeah, that's right. And so sometimes you may want that right yourself, so that you can go in and audit their use, inspect facilities, make sure that they actually are following the processes they've said they're going to follow.
And I think with all of these items that are additional to what HIPAA might require, you're not going to necessarily push as hard on every vendor for them. So you want to think about what vendor has your most sensitive data and what vendors are your biggest targets in terms of getting a good contract, and then, allocate your resources accordingly.
And that's how the risk assessment absolutely feeds into the way that you manage your vendors. If it's sensitive information and there's likely harm if it's released, then you're going to want to really think hard about the contract with someone who's managing
Sure.
that data, maybe differently than someone who just has incidental access or is playing a less important role.
So definitely make vendors a category in your risk assessment.
Absolutely.
So, the PHI has to be returned or destroyed at the end of the contract. I've honestly never gotten into much in the weeds about this from a HIPAA perspective, but tell us what we want in a best practice.
From a business perspective, and again, depending on what the vendor is doing for you, you need to think about this not just from the confidentiality and security standpoint, but just the practical. Do you have access to this data to continue to use it in the way you were using it before in a business operation? So again, I guess the hosted or cloud-based scenario is the one I think about most. People often overlook addressing in the contract up front how they're going to get the data back at the end. And the details around the formatting and how that happens, how it's transferred, whether it can go to another third party, and what kind of cooperation the vendor will provide and what that costs, can really cause some problems if you haven't thought that through. So if the vendor's going to just give you back a paper copy of something you've been maintaining electronically, or if having the data moved is going to require a lot of conversion, that could be quite expensive. So again, worth thinking through up front.
And certainly the covered entity has to be able to terminate the BAA and presumably the entire services agreement, because it's dependent on getting access to PHI, if there's a material breach, and that's something we want to see in business
Right.
practice too.
And sometimes we'll want to actually define up ahead of time what kinds of things would absolutely be material, so we're not arguing about it.
Right.
Yeah.
And certainly some of the things that we argue over the most in business associate agreements would include indemnification. I did mention that you want that to cover not just notification costs, but
So
additional.
not required under HIPAA,
Right, not
but,
required.
Certainly worth considering and equally applicable even if you're not doing a business associate agreement or some other kind of contract where someone has access to personal information or confidential information, where you want to make sure you're covered not just on your losses but your costs of complying with legal notification requirements or dealing with another third party whose rights have been impacted. There's some other things we talk about and think about when we're entering into contracts with a third party who's going to have access to or particularly manage data. Again, whether or not that's PHI, you want to think about and ask whether the vendor has a good disaster recovery program and a good backup process so that if they have an issue, that doesn't become your issue. And so as part of your diligence process, as part of the contracting, you want to understand, again, if they've got a database that you're accessing, what happens if their data center in Phoenix goes down? How will you have access to that? And so questions you need to ask up front and may need to contract that to require that they have some redundancy, that they're doing offsite backup, et cetera. The same kinds of things you do internally. People often, we're all drawn to the cloud as an option because it takes away some of our own internal administrative costs and complications, but you can't just assume that the third party is now covering those things. You've got to ask. Yeah. And insurance is another thing that we will often ask about. If you're getting indemnification, that's great. You may want to make sure that's backed up with actual third-party insurance that the vendor holds that runs to your benefit. And that has been an evolving area, especially in the technology space. So we'll talk a bit about cyber coverage later, but there are other kinds of technology insurance policies that may be helpful for a vendor to have in place that just deal with business continuity as well. That could be of a benefit.
There's a question that just came in that raises an interesting area. So the question is if a contract continues to be renewed, or I guess if there just is a contract, are there standard data retention guidelines if they're not specified in the contract? Now, I mean, there are, I would say your agreement is what's in the contract, and there aren't really universal data retention guidelines, but
Not that would apply to a vendor,
Right.
I think. I think they would have their own retention guidelines for their own information, but not for the information they're holding on your behalf.
So if you are in a state that, well, certainly HIPAA requires you to maintain certain information for 6 years at least. If you're in a state that requires retention of medical records for a certain length of time, you want to make sure that if a vendor is doing that, then that's in the contract. Otherwise, I would say you can't go after the vendor for that.
Right.
So Anne, how do we do diligence on our vendors?
Yeah, so this is a complicated and tough area. We've spoken about the number of data breach incidents that have been caused by behavior at a vendor. So what can you do to try and minimize the likelihood that that's going to happen? It's not required, at least it's not required in the regulations at this point, but just certainly a good business practice and maybe becoming an expected business practice, and failure to do that practice may be rising to the level of maybe not negligence, but sort of not doing the things you should be doing as part of your good oversight of your business, setting aside, again, what you need to do under your risk assessment.
In the St. Elizabeth's example, there was a mention in the resolution agreement about failure to do risk assessment with regard to that vendor. So that's hinting at, basically.
Yep. So, in essence, what we're looking for are examples that the vendor is actually going to do the kinds of things you expect them to do, whether that's complying with the requirements under a business associate agreement or complying with the separate security and privacy obligations that you have imposed under your contract. So some examples, you're going to want evidence, and you do this, we'll talk about how you might do this, but you're going to get evidence that they've used good physical security at any location where they're hosting PHI on your behalf. data centers, et cetera, that those centers are appropriately secured, that they have fire suppression, all those kinds of things you'd look for if you were hosting the data yourself. Similarly, that they use good network and system security, like firewalls and intrusion detection, that they're doing that patching that we've mentioned being an issue, that they've got a regular process for making sure if there's a security patch that's issued, that they're getting it installed, and that they have good internal policies and procedures, the training, maybe background checking, and their own good security breach response. That's an important one to call out, because if you think about it, you need to know if there's been a problem, because whether you know about it or not, you've got an obligation, right? So you need to have a vendor who you feel pretty comfortable is going to be able to let you know if there's been a problem. And I think some of the situations where we've seen a long period of time between the time an incident occurred and the time it was reported have been because maybe the vendor knew about it, but the covered entity didn't, or no one was aware of it, no one was escalating it. So that's an important thing to pick up on. So how do you do that? A lot of times through a questionnaire, and we've got an example, simple questionnaire. I'd be glad to share if anybody's interested. It really does just ask those kinds of questions. Where do you store the data? What are your security systems there? What are your policies around patching? What are your policies around training, etc.? And probably should have made this point early on. With all of the things we're talking about, this is no longer just an IT issue. I think in the past we might have all thought, well, this is really, it's technical security, the IT group can deal with it. But many of these questions go to things like, are people being trained, and how you will let us know if there's a problem. That's not just a technical IT question. So if you're going to do a questionnaire and you're going to then look at the answers, you need to have somebody who has both the technical expertise looking at those answers and somebody who's thinking about it from kind of the administrative, how are we going to really operate under this contract perspective. So that's one common way, some diligence questions, and maybe, again, depending on what they're hosting, an inspection. So if it really is a data center hosting an electronic medical record and you have some reason to be concerned, maybe it's worth actually, stopping in and looking.
Sure.
I'm not sure how often that happens, but it's worth thinking about. For some other kinds of EPHI, if you think about connected electronic medical records, there are the manufacturer's disclosure statements for medical device security that, again, are just a series of questions, but go to more security around the device. So if you think about devices you're bringing in that have electronic PHI on them that are connecting to your systems, that's a good way at doing some of that diligence. And there can be third-party certifications where if somebody's getting ISO certified, then that's almost a shortcut. They've gone through the diligence and someone else has looked to see whether they've met the standards. So that can be a shortcut as well, if they've gotten a third party to look at them.
One person just asked, what kind of extra considerations should you make for a vendor that appears on the wall of shame data breach list? That's a good question. I would actually just pose that question directly to the vendor and say, we see you've had an issue before. What have you done to fix it? What's different now?
Yeah. It's kind of it relates to our next bullet, what to do if a vendor messes up for you. And again, I think if you're going to be judged by a standard looking back in hindsight, which is always going to be a higher standard than when you're doing it today, right? Was it reasonable to continue to use the vendor? Was it reasonable to engage that vendor? You'd want to ask some hard questions, right? How have you fixed it?
Right.
Yeah. How do I know it's not going to happen again?
All right.
So what do you do then if there is a data breach? Because things happen, people make mistakes, your employees might make mistakes, and there are bad people out there always trying to get your information. So what do you do? First thing, get your team together. So the team might depend on the type of disclosure or problem that you've got going on, but generally you would want to see some compliance people, your legal folks, including outside legal counsel, somebody from IT if it's an electronic security issue, privacy officer and or security officer, Generally, people who are going to know about the situation, the business person that works with that vendor, you might have a large team that is getting together to figure things out. So when that team is together, the first thing I would want to do for HIPAA purposes is say, is this actually a breach? And state laws may differ for other types of reporting that you might have to do, but for HIPAA purposes, figure out if it is a breach. And there on the screen is the definition of what a breach is. The acquisition, access, use, or disclosure of PHI that's not permitted under the privacy rule, and importantly, that compromises the security or privacy of the PHI. So if something is a not permitted use or disclosure, it's presumed to be a breach under the regulations, but you still are supposed to do a risk assessment of the factors to say, okay, is this really a breach or not? So you are supposed to look at the nature and extent of the PHI involved, the kind of identifiers, the likelihood of re-identification, the unauthorized person to whom the disclosure was made or who made the use of the information. So there, for example, I would say, okay, is the person who got this information the ex-husband of our patient, or was it a doctor at another covered entity who's not going to do anything with the info? Look at whether the PHI was actually acquired or viewed. We've had at least one, maybe two cases where employees found copies of paper records just in the bushes outside of the hospital. And the employee gathered them up and they shredded them up or did whatever other disposal necessary. So it was not apparent that the PHI was actually ever acquired or viewed by anybody. And so then I would tend to say, okay, probably not a breach, even though that is obviously not best practices. And then the final factor is the extent to which the risk of the PHI has been mitigated. So if something was given to an unintended recipient, they shouldn't have that, but maybe the recipient says, oh, I saw this had somebody else's name on it, so I didn't read it and I immediately shredded it. That to me says you've probably mitigated the risk to that PHI, and so probably I would consider that not a breach. The regulations were changed, and they were supposed to make it more of a bright line rule of here's what a breach and here isn't, but really the analysis is still necessary, and really there are many situations where it's not a bright line situation. One thing I do want to point out too is there's no exception for a notification of a patient where it would cause more trouble than it's worth. So we've had a couple cases where, it's a 98-year-old patient and somebody received their discharge instructions instead of their own. Just pure human error. The person gave it back to the hospital. There was really no harm done, but the information had been compromised. Somebody got it. Somebody looked at it. It was their discharge summary. And then the question is, are you going to tell this poor 98-year-old person who, it doesn't affect them badly that their PHI was out there, but it was, and what do you do? And OCR does not have an exception for that, so that really is kind of a judgment call. So again, as Katie mentioned, you do have to do a notification. If you've determined that it really is a breach, you've got an obligation to notify OCR, and that's for all of the breaches, even if it's just one person. There is an annual reporting requirement. I think it is by February 1st that your full year's worth of, calendar year's worth of stuff needs to be reported to OCR and can be reported electronically. If it is 500 or more individuals, then you've got an obligation to notify OCR right away. You also have to notify the media. And here is where you might want to add a PR person to your response team, because that can be a big, giant mess. Outside vendors are important here too, not just for over 500, but depending on the type of information and what you've got out there. You might need to hire some credit monitoring agencies. You might need to hire forensic investigators to figure out what happened. So again, you'll have to have that team look at what's going on. And another note here is, once you've got this team going, once you've figured out what's going on, once you've done your notifications, start fixing the stuff that caused the problem. Don't wait until OCR or some other agency comes in and says, you didn't do X, Y, and Z. Once you figure out that the printer is printing to the wrong place, get that fixed right away and document that you fixed it, because again, as Katie said, OCR may be asking questions about this 2 years down the road, and you don't want to be guessing at what you did or didn't do or when you did it. So keep a timeline, keep documentation of what you did, and fix it as soon as you can.
So Briar's hit on a number of these issues. As she's described what you need to do if there's a breach, I think you can all see that it makes sense to think about those things ahead of time and try and put together a plan so you already have a list that includes the phone number for law enforcement, or the phone number or contact information for credit monitoring services, a PR consultant. If you're trying to scramble around after the breach has occurred to put those things together, that can be add some additional stress in an already stressful situation. The other thing I just want to point out here is that it's important to think about the communications to your other stakeholders, including the board of directors or other people in management. One of the things that's happened recently is that members of boards and executives have been put in the hot seat if there have been data incidents, and actually have been sued in some circumstances. And there have been lawsuits against boards that have been dismissed because the board has been able to show they played the proper oversight role. They were dealing with the problem once they learned about it. They were getting regular updates and making sure that that remediation that Briar just mentioned was actually happening. So it's important, both operationally, but also to, again, show that you've done things the right way, to keep people in mind. So main point here is don't wait till you've had the breach happen to think through how you're going to do all these things. Put the plan together in advance.
We'll just briefly talk about employee training, not because it's not important, but because we're kind of running out of time. Employee training is required for HIPAA purposes, and in healthcare, about 1/5 of all these data breach incidents are based on simple human error. So giving somebody the wrong discharge instructions, or faxing stuff to the wrong place, or any number of little human problems. So do your best to train employees on the right way to do these things, and particularly how to securely send, store, and dispose of PHI. And we will talk about some of that as low-hanging fruit. So again, what to expect if you have a problem. Katie covered some of this in her discussion of some of these more publicized issues, but usually an OCR investigation is going to be based on a complaint that somebody made against you or a breach report that you have filed yourself. Audits are becoming a little more common, and Katie will talk about that. Usually OCR's investigation starts with a letter saying, you have been accused of doing this bad thing, please provide us your information and explanation and why you did, or explain it if you didn't do it the way that this person said. Again, keep good notes, keep a timeline on all of this, because it's going to be a long process. Most of the complaints that we see from OCR, thankfully, are resolved without any major issues, without a resolution amount, without any kind of settlement agreement, certainly without civil monetary penalties. So odds are good that if you do a response, you do an appropriate response, you will just have some sort of finding that will say you need to fix this. It won't be a big public problem. But sometimes there are major issues, and when there is, OCR will send you another letter, maybe 2.5, 3 years later, that will say, here's the resolution amount, here's what we think that you owe us for this bad thing that you did, and here are all these things that you have to do in your resolution agreement to make it right. That then should set off a negotiation process. You don't have to just write the check when you get that letter, but at that point you'll want to get your legal department involved and make sure that you've got people responding to that and fighting for your rights on that one, because you don't want them to overstep their bounds, and you don't want to be held to a standard that is not an actual standard. And then, of course, there are other problems that can happen. There are other federal or state level investigations depending on the problem. People can take private actions. They can sue you even though there's not a private right of action under HIPAA. It might be an invasion of privacy issue. It might be a class action lawsuit that somebody files. There are any number of things. So again, keep good documentation, fix things as you are going along, and keep a timeline that shows when you did what.
All right, we are at about 1 o'clock, but I know we still have people on the line. We have a couple more things to cover, so we're going to hang on. I will just say briefly that the HIPAA audit program, which was put in place by the HITECH Act, is still underway. Phase 1 is over. They audited 115 covered entities. There's a report. I'm happy to send you a copy of that report if you would like to see it. One of the big things that we've harped on here is that covered entities were not doing risk assessments or risk analyses. So it is actually important. Phase 2 is currently being, the group of organizations that are going to be audited are currently being put together, is my understanding. Ultimately, it will be 150 covered entities, as well as their business associates, or some of them. And so this is going to be a different focus. It's going to be focused on the organization and business associates. In fact, there will be data requests directly to business associates, and so even more important to make sure you have those relationships in place where you want them to be.
So we've given some lessons learned throughout this presentation today around risk assessment and vendor management, etc. Here are a few other tidbits, things that are most likely to have a big impact with hopefully less investment and worth considering thinking about today. Verizon does a report every year, and they issued one in 2015 on data breaches, and they reported that 70% of those hacker attacks, the intentional espionage, exploit known vulnerabilities. So things that people already know are a weakness in a particular piece of software where there's a patch and it just hasn't been installed. So make sure that you've got good patching processes and you're keeping your systems up to date, and that your vendors are. Encryption is a very helpful thing to have had in place. If you've had an incident and something's been accessed, but it was encrypted and the encryption hasn't been affected, then you haven't had a breach. And under state law, you fall into an exception in all the states. So encryption is worth thinking about where you can do that and not affect operations. So kind of low-hanging fruit if it's something you haven't been doing and you can. And think about that again on things like thumb drives and other portable communication devices, adding that level of security. I'll mention one other one in the sort of IT area, and that's the phishing scams. Really, you address that with employee training, but also worth noting that Verizon reported that 2/3 of cyber espionage use phishing scams as some part of the plot, as I mentioned in the Target and Home Depot case. And still, as of their last report, about a quarter of people were still falling for those. We're still opening the email, and 11% were still opening attachments. So if you can get employees to stop doing that, you can have a big impact.
So certainly when you're doing your HIPAA training, you don't want to just talk about patients' rights and things like that under HIPAA. That's required, but give your employees practical tips about how to recognize an email that's a scam. That will definitely lob off probably a big chunk of risk right there.
Right.
We've seen anecdotally a couple other things. The first slide I had talked about where data is that has been breached, and it's still, a lot of it is on paper. So make sure you have a good shredding or destruction program. We've also seen where a laptop may be encrypted, but you have the Post-it with password on the laptop that's then stolen from the car. Theft, again, appears to be the biggest source of problems, at least as of the spring.
And bigger in the healthcare industry than other industries for some reason.
Who knows?
Yeah.
Maybe the vendors are using their laptops to do various things.
Yep.
So we'll just talk briefly about insurance. I hear a lot of clients say, well, our malpractice carrier has some coverage for cyber liability, so I think we're okay. But in fact, that may be sort of added on to your malpractice coverage at no expense, but the limits are often terribly inadequate. So my advice is to any healthcare organization to go out and seek out the best coverage.
Yeah, and general liability may not cover, and that's becoming an area of a lot of litigation. As you can imagine, a lot of people who've had an incident are going back to the general liability policy, seeking coverage. IBM had a vendor who had some tapes fall off a truck that had personal information on them, and the vendor tried to go to its general liability policy and took that to court, and the insurance company won, wasn't covered in that circumstance. So really having that specific cyber liability coverage is worth exploring. It used to not be that expensive. It's going up, but it's it can be helpful because it covers not only the actual losses, but also the costs of the breach notification. And if you have to get credit monitoring, it'll cover that cost as well. So worth exploring that with your insurance broker.
Right. So we're past the time. There are a couple people still on. We have at least one question. It's a good one. The question is, are you using the terms risk analysis and risk assessment interchangeably? In fact, I probably have been using those terms interchangeably. When we're talking about risk assessment in the HIPAA context, we're talking about the assessment or analysis that has to be done under the security rule for all of your electronic and other PHI. We're also talking about the assessment that has to be done when there is a potential breach and you have to figure out what is the risk that information has been compromised. So the rule has, and I honestly can't remember which part of the rule uses analysis and which uses assessment, but those are the two places it appears in HIPAA. And even if you're not a HIPAA covered entity, you want to be doing both of these types of analyses.
And even if you're not a HIPAA covered entity, a risk-based approach to a cybersecurity program is the way to go. Know what you have, know how it's vulnerable, think about the consequence, and then protect accordingly.
And I think that covers our topic today. So thank you very much for joining us. Stay tuned for our next webinars as they come up on the calendar.
Thank you very much, everybody.